courtroom too.
Yeah, go ahead, Tucson.
I got 9 and 11 released. Is that true? That's what I saw this morning.
Yeah, give me the name. What's your name?
Newman
That's correct.
and Pedro Nicholas.
That's correct.
Cool. Anybody else?
We have
Pablo.
Pablo?
Pablo, number 10.
Oh, 9 and 10. Okay. So 9, 10, and 11. Cool.
it really should be like 8 positions really that we have total.
Really?
To be honest, yeah.
Um,
Tremaine Hurt, his bond was paid.
Hurt.
Position 4.
Um,
Nathaniel Powell, position 12, gonna be on MH reset.
Powell.
It's gonna be a what?
MH.
MH. What's tomorrow? 26.
Torres Morales, he waived his appearance. That's position 8.
My bad. Which one was the MH 12?
Yeah. Powell.
Yeah, MH reset.
Hurt.
It's an MH reset, but I think we're gonna try to do him though, because she did get the notes on him. So we kept him up here.
Who?
Yeah, we should be good.
Wilson. Let me call my judge.
The state on?
Yeah, everybody's here.
Your judge?
All right, there we go.
Yes, Your Honor.
All right, good afternoon, everyone. We're going to begin our Fulton County State Court Expedited Accusations calendar. And this is a calendar for cases in which individuals have recently been arrested and charged with certain misdemeanor offenses. Soon after their arrest, the Fulton County Solicitor General's office has already accused the cases of the offenses brought against them, and these cases have been bound over to the Fulton County State Court. Nevertheless, this will generally be the defendant's initial appearance before a state court judge, so we are able to address several matters, including bond, possible arraignment, and a possible plea offer if one has been made by the state at this juncture. I'll also be providing you, excuse me, with a reset date for SAP or arraignment, and that date is
July the 8th.
July 8th. All right. Also, I want to begin by advising everyone that this whole entire proceeding is being recorded as well as live streamed on YouTube, so govern yourselves accordingly. I also want to advise the defendants on this calendar that you have certain constitutional rights. The first being that you have a right to remain silent. Remember that anything that you state about the facts, the circumstances, or the occurrences of your case can and will be used against you. The state is here and they're listening. You also have a right to counsel. You should know who your attorney is by now and have spoken to them about the case, so follow their lead. All right, who do we have?
We can start with position 12, Judge.
Okay. I'm looking at the chat notes, so I guess, Ms. Strong, you're handling that.
Yes, ma'am.
Okay,
And
thank
Judge,
you.
we may want to bring up, is it position 7? This was a dual arrest here.
All right. All right, so 7 and what was the first one?
The first one was 12, Judge.
So we are doing power.
Right, so we're gonna do 12.
My
Right.
understanding is that Powell is a MH reset.
Mm-hmm.
I know the courtroom 2 said they would try to bring him up.
It's Powell, is that who's in front of me? Courtroom 2?
Yes, Judge.
Okay, that's Powell, okay. All right, do we need to go in a breakout?
I don't believe so. Don't worry about it. So,
Well, if we're gonna talk about MH, we do. Let's get started and see real quick. 25 CR 0035553Y, Nathaniel Powell, charged with 1 count of affray and fighting.
This is 9th arrest. 2023 larceny, resisting officer, simple assault. 2023 robbery with a weapon. 2020 theft. 2012 injury to real property. Attempted break and entering, that was dismissed. And 07 assault dismissed. That is for Powell. You want McIntosh now?
Let's hold for a second. Let me see. Powell. State, go ahead.
Thank you, Judge. So this took place yesterday. Law enforcement observed a fight in progress at 180 Shirley Franklin Boulevard in Atlanta. It's the state capitol building. This was right out front. The officer, while on patrol, observed a black male in gray clothing strike the defendant and in the mouth with his right, causing with a closed fist, excuse me. Officer approached the two. They were fighting. And after reviewing the Capitol Hill security system cameras there, that footage, it was determined that both parties were the aggressors here. The defendant was identified by his Georgia ID and was placed under arrest. As you heard, he's has a recent violent case history. So the state is asking for a $2,000 surety, 2-day anger awareness, no further contact with Leland McIntosh, stay away from the state capitol building at 180 Shirley Franklin Boulevard in Atlanta, and no drugs, weapons, or alcohol while out on bond.
All right. Attorney McLeod?
Yes, Your Honor. My client is currently unemployed, so he doesn't have any money to pay bond. He denies that he was the primary aggressor in this matter, Your Honor. In fact, I do believe that the warrant says that the officer first noticed the other person striking my client. Given the fact that he was the victim here, I would definitely argue that. I would ask the court to consider giving him a signature bond. Otherwise, he's just going to sit in jail because he has no money to pay bond. Nothing further, Your Honor.
And just to clarify, that's where the officer came in to view the situation. I mean, he went back and reviewed that security footage, which showed them both as the primary aggressors.
All
I'm
right.
not sure how both are the primary aggressors. Somebody has to have started it, Mr. Scirocco.
Agreed to engage in mutual combat. Ms. McLeod, that seems like what the case is here.
All right. I'm going to order the $2,000 surety bond. I'm going to order that he stay away from the state capitol, 180 Shirley Franklin Boulevard. Have no further contact with Mr. McIntosh. No drugs, alcohol, weapons, or guns while on bond. I guess that should be it for now.
Your Honor, my understanding was that he actually had a $600 bond before.
Did he?
That's my understanding.
Don't have that information. See if Mr.
It's
Scirocco
600.
can find it.
It's 600.
I would prefer to Mr. Scirocco to leave it at the 600. He's already had a bond. And so why is he on the calendar again today?
I'm not sure, Your Honor.
I know we kind of talked about that, but
Just out of curiosity, was that the bond set by the magistrate court?
Correct. It's on the warrant.
Okay, so,
Oh.
Your Honor, and I do definitely want to talk to Your Honor and the other judicial officers when we start next on July 7th, when we move to that modified version where we're not going to be on Tuesdays and Thursdays.
Okay. Okay. Well, I don't, like to do that. And thank you, Deputy Falk, for letting me know and clearing that up a little bit. But, I try not to unless we need to increase it and there's some circumstances that would warrant that. I don't like to do it, but, considering what happened, it was a fray, mutual combat. I will retract and I'm going to leave his bond at $600.
Thank you, Your Honor.
All right. Thank you.
Next is position one, Ms. Bell.
This is 25 CR 003547C. Stephanie Bell, charged with 1 count of battery family violence, 1 count of simple battery family violence.
The third arrest. We got to open obstruction. It's 24 CR 000-838C. 2022 simple battery DV. That was non-process.
All right.
My apologies. Mr. Howard, can you please give me the case number on that other case again?
Which one? The one I just called up?
Yes.
CR 24 CR 000-838C.
38C. Thank you. I appreciate that. All right, Your Honor. So the previous case that she is currently on bond for was in 1000 SOB through the jail. That was for a willful obstruction. In this case, This incident happened on June 8th of 2025 at 2553 Log Haven Drive, Northwest in Atlanta. The defendant went over to the home of Mr. Tyrus Daniel. He and his mother lived together at that residence, and she came over and attempted to break out the window on his mother's car. Upon being unable to do that, while Mr. Daniel was trying to stop her, the defendant then started swinging a phone charger and striking him across the face, causing swelling and kind of a bruising across his left cheek and neck. After he stated he was going to call the police, she ran back down the street and fled the location. Both Mr. Daniel and his mother said this is not the first time that this has happened. She has come to their home previously and damaged property at that location, and she has threatened them in the past. And they previously had to take a TPO against her. However, the TPO was dismissed because the defendant couldn't make it to court because she had been admitted to the hospital. We are on this case, Your Honor, it appears that when we did reaccuse the case to add some additional counts. So on the family violence battery, we were asking for a $3,000 surety bond. No further violent contact with Mr. Tyrus Daniel. However, we are asking for a stay away from the address listed at, 2553 Log Haven Drive Northwest in Atlanta. We're also asking that the defendant have no contact whatsoever with the mother of Mr. Tyrus Daniel. And I'm not sure I know she should be here. She can provide her name so that we can have that for the record. That would be helpful because it is not in the warrant. Also, we are asking for 3 days of anger management and no alcohol, drugs, or weapons. And on count 2, the simple battery, we're asking for a $1,000 surety bond on that count, same conditions. We would like to sound for Mr. Tyrus Daniel or his mother if she is here.
And let me make sure, Deputy Falk. Hold on, ma'am. Deputy Falk, you said no further violent contact?
With
Or no further
so we did have a conversation with Mr. Daniel. He does want to continue contact. It is his mother who wants her to stay away from the home. So we are trying to accommodate both of those wishes.
Okay. And I think the mom is on, ma'am. Are you the mother for Mr. Daniel?
Yes, good afternoon, Your Honor. Yes, ma'am, I
Good
am.
afternoon. What is your name, ma'am?
My name is Darlene Alfred.
Spell the last name.
Alford.
Okay, Darlene Alford. All right. And you're the mother of
Yes.
Tyrus Daniel?
Yes, ma'am.
All right. Do you wish to make a brief statement or answer a few questions today?
Yes, ma'am.
Raise your right hand for me so I can swear you in first. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes, ma'am.
All right. You can put your hand down. Are you in fear of Miss Bell?
Yes, ma'am. Yes,
Do you
Your
want
Honor.
Okay. Do you want to have any further contact with Miss Bell?
No, Your Honor.
Okay. And you want her to stay away from your home and stay away from you, correct?
Yes, ma'am. Yes, Your Honor.
Okay. All right. That's all I need. Any other questions by the state, or is this your case, Ms. McLeod?
It is, Your Honor.
Okay. State, do you have any questions? Okay. All right. Ms. McLeod, any questions?
I do not have any questions for her, Your Honor.
Okay. All right. You can mute yourself, Ms.
Yes.
Alfred. Appreciate you for coming on the Zoom. Thank you. All right. Go ahead, Ms. McLeod, Attorney McLeod.
Your Honor, I'm asking for a signature bond for my client. She is 21 years old and she has no significant, in fact, she has absolutely no convictions. Yes, she's had 2 prior arrests, but one of them was dismissed outright, and one is still pending. And based on what she tells me, there are definitely some issues concerning police officer conduct in that one where she is charged with obstruction. So, given the fact that she has no significant history, I think a signature bond would be appropriate, Your Honor, and her not having any further contact with mom is just fine by her. And given the fact that she and the gentleman share a 9-month-old child, it probably is prudent that they do have the opportunity to have communication with each other because they do have to parent a child together. So again, I'm just asking for a signature bond for her.
All right, I am going to grant the $4,000 signature bond through pretrial and level 2. And that would be 3,000 on the battery family violence and 1,000 on the simple battery family violence for a total of 4. And the stay away from 2553 is at Long Haven Drive. She is to have no further contact with Miss Darlene Alford, to stay 200 yards away from her, not to contact her in any manner. No cell phone, no emails or nothing. She's to have no further violent contact with Tyrus Daniel. And no guns, alcohol, weapons, or drugs while on bond. And I will order her to take 2 days anger awareness course through pretrial.
Thank you, Your
Anything
Honor.
else? And I think that should be it. Anything else?
Nothing that I can think of, Your Honor.
Okay,
Nothing from the state.
thank you.
Thank you, Your Honor. That concludes my business before the court today. May I be excused?
Yes, you may. Thank you.
You're welcome.
All right.
Good afternoon, Your Honor.
Good afternoon.
I have before you petition number 3.
3. Okay. This is 25 CR 003549H. And this would be Melisha Gabidon or Gabidon. I'm not sure how to pronounce the last name, so I apologize. She's charged with 2 counts of simple battery family violence. Pre-trial.
I got second arrest. The last arrest was out of New Jersey for drug possession. It was no bill. It was a weapons and drug possession. That's it.
All right. State.
Yes, Your Honor. This incident happened on June 24th of 2024 at 11:10 a.m. at 1240 West Peachtree Street Northwest in Atlanta, Georgia. Officers responded to that location and spoke with Miss Richie Ann Jackson, who stated that she and her wife of over a year had been in a verbal altercation, and the defendant grabbed her by her arm and hair and then pushed her into a glass wall inside of the apartment they share. We did have an opportunity to speak with Miss Jackson, and she kind of gave us some additional information that is causing some concern for the state. Specifically, when we spoke with Miss Jackson, she stated that she was not afraid of the defendant, but she also stated that there had been an incident between them where the defendant squeezed her by the neck and squeezed her windpipe. We did do a strangulation assessment. She rated the pressure at 8 or 9 out of 10 and did state she was unable to breathe. Based upon that, the state has recommended this case to the DA's office as an aggravated assault strangulation. Additionally, we have been able to obtain the jail calls in this case. And in the jail calls, the defendant does call the victim and states, you never cared about this marriage from the beginning. That triggered me, which is why I pulled your hand, pushed you on the wall, and squeezed your neck, and you never reacted. And Miss Jackson then says, I was so shocked because you promised me the last time you wouldn't do this, and then the call ends. During another call, the defendant says, excuse me, Miss Jackson says to the defendant, I've told you that you can't put your hands on me when you get mad. So clearly there is two problems here that the state sees, despite the defendant's lack of history. One is that this clearly, based on the jail calls, has been an issue that has occurred before, issues of violence between the defendant and our victim, Miss Jackson. The second issue is that there is clearly an admission here of aggravated assault strangulation. The state has also sent those jail calls to the DA's office to have them reviewed to see if this case will be accepted as an aggravated assault strangulation. We are still waiting on a response from the DA's office since these jail calls were obtained within the last hour or so. For that reason, the state's recommendation is going to be a $5,000 surety bond. We're asking for no further contact whatsoever with Miss Richie Ann Jackson. We're further asking for a stay away from the residence at 1240 West Peachtree Street Northwest in Atlanta. No alcohol, drugs, or weapons. We're additionally asking for a family violence intervention program. The state normally does not request that on a first-time family violence battery. However, due to the unique circumstances of this case, and I'm sure as your honor knows, strangulation is one of the highest indicators of lethality other than handguns. We do have some serious concerns here that there is escalating violence in this home. We would at this time like to sound for Miss Richie Ann Jackson. That's all for the state.
Thank you. Miss Richie Ann Jackson. Don't think I see her. All right, PD Tucker.
Yes, Your Honor. Miss
Yeah, she's
Gabardon.
unmuting. I apologize. Miss Jackson is unmuting.
Yes, I am.
Oh, is she?
Yes, I am. Okay.
All right, Miss Jackson, do you wish to make a brief statement to the court today?
Yes.
Hold on a second, and then let me swear you in first. Raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
Yes.
All right, put your hand down for me. Are you in fear of Miss, and pronounce her last name for me?
Gabardon.
Gabardon. Are you in fear of her?
No.
Do you want to have any further contact with her?
Yes.
Okay. All right. I don't have any other questions than that. Anything from Deputy Falk? Any questions?
Yes, your honor. Miss Jackson, who called the police in this incident?
I did.
Okay. And is it correct that you did speak with our victim advocate and let her know that hands were put around your neck and pressure was applied?
Yes.
Okay. Thank you. That's all for the state.
Okay.
All right. PD Tucker. Oh, you're muted.
I did have a question. Are you currently staying at a hotel, Miss Jackson?
Yes, but I have access to my home. I already booked the stay, so I'm just remaining here.
Okay, thank you. I have no further questions.
Okay. All right. You can go ahead and present. You can mute yourself, Miss Jackson.
Okay.
Thank you.
That's my statement.
Yes, that briefly, would you like to add something else? You're muted.
Yes, can you hear me now?
Yes.
Yes, Your Honor. If I may interject, and this is in no way to not the seriousness of the situation, I wanted to speak that I don't know how this process goes because this is her first time and equally mine dealing with the situation. As two women, it does and sometimes get very, very aggressive, right? And because we're both females, we both have emotions. So I definitely want her to get the chance to work on how to manage her anger, right? Never, and I will say this here, never have I felt like I was going to die or she was going to, and I'm not saying that right now to make it, I'm just telling the truth here. Never did I feel like I was going to die, but it doesn't hurt any less. No, normally, if she attacks me or if she gets angry and she puts her hand, I'm fighting back. In that moment, I didn't because I didn't think that we've addressed it and we've tried to find ways for her to cope with her anger, but we have not done therapy for it. And we have not done or seek professional help. So I'm just essentially just frustrated with her not controlling her behavior when she gets angry. And I want her to understand that there are better ways to deal with it.
All
Right?
right.
So
Thank you. Now,
my
this is not your trial.
right.
This is just a bond hearing.
Mhm.
So that's why I said a very brief statement. I don't usually go into too many details of the facts at this point,
Right.
because
Mhm.
that is not somewhat what we're here for. I'm just
Right.
wanting to make sure that you're going to be safe, that you will not be subject to any more violence at the hands of the defendant. And
Right.
so that is what I'm trying to make sure of, depending on what we do with the bond. And but our first concern is that you will be safe. Okay.
Okay. Thank you.
Thank you. All right. PD Tucker.
Yes, Your Honor. Miss Gabardon is 48 years of age. She has maintained her residence at 1240 West Peachtree Street for 3 years, which is how long she's lived in the Atlanta area as well. She also has some family in the area. She's completed some college focusing in architecture, and she's been employed at Think Mortgage for 4 years now. We are objecting to the state's recommendation for a stay away, requesting that she be allowed to return to her residence upon her release. Her name is on the lease for the place. As I said, she's been residing there for 3 years, and she stated that she does not have anywhere else to go. And she also told me that Miss Jackson had left the property and had been staying in a hotel. We are also asking that for no violent contact moving forward. Um, and we are requesting a signature bond on her behalf, as has been stated on the record. She only has 2 arrest cycles. Her last arrest dates back to 2003, over 2 years ago. 20 years ago. She has no prior failure to appears. So it's appropriate that we ask for a signature bond on her behalf.
All right. And this happened roughly 24 hours ago. I am concerned about the allegations. I'm going to order the $5,000 surety bond, which would be $2,500 on each of the charges, for a total of $5,000 surety. I'm going to order, out of abundance of caution at this time, it is pending recommendation to the DA's office that no further contact with the victim at this time. It hasn't been 24 hours quite yet. So no further contact and a stay away from 1240 West Peachtree Street, not Northwest.
Can I
They,
say something, Your Honor?
no, ma'am. No, you cannot. Thank you. No, I don't want you to interrupt me while I'm giving my ruling. And with that 5,000 surety, no drugs, weapons, alcohol, or guns while on bond. So that is the ruling of the court. I'm not going to order an FVIB at this point, Deputy Falk, but I do understand the urgency and the seriousness of it. It probably should be, but I'll hold for a moment on that.
And Your Honor, just to update the court, the DA's office just sent me an email saying they are accepting this case as an aggravated assault strangulation. I will send the order for your signature today.
All right, great. Thank you.
Thank you.
All right. Next.
Next, we have position number 5, Ms. Kimbrough.
And you're free to go, Ms. Jackson. Thank you. This is 25 CR 0035551B, and that is Diamond Kimbrough, charged with 3 counts of battery and 2 counts of simple battery.
First.
Oh, I see. Thank you. State.
Yes, Your Honor, if I may just have one moment.
Uh-huh.
My Odyssey has decided to cause a little bit of trouble.
Yeah. Technology.
Just to give you kind of an overview of the victim, we did have an opportunity to speak with the victim in this case, who is here today. She did state that she and the defendant are best friends. They were living together at the time of this incident. The state declined to charge a family violence battery due to the fact that they are roommates. There is not an intimate partner relationship. And so we felt it was just in the best interest to charge this as a battery. She did state that everyone was home at the time of the incident. Everyone witnessed the incident. And she was in the kitchen with another tenant when the defendant said, "You don't have to leave the kitchen when I come up to the kitchen," and called her name. The victim proceeded up the stairs where they lived. The defendant followed her and charged at her and began to assault her. She stated she has multiple lacerations to her arms, face, stomach, and back. She also stated that the home is owned by someone else. The defendant also threw a lamp at her, at another tenant, and tried to push another tenant down the stairs previous to this incident. And the defendant has an 11-year-old son who observed the incident, told police what his mother did to the victim. She stated the defendant stopped being friends with her in February and continues to verbally harass and provoke her. She does want no contact and for the defendant to stay away completely from the residence. That's just to give you an overview of kind of the ongoing issues between the parties. This incident happened at 12515 Magnolia Circle in Johns Creek on June 23rd of 2025. Miss Jonna Muse was at the residence, was in a verbal altercation with the defendant, and the defendant pulled Miss Muse's hair from her scalp with a lot of force, actually ripping her hair out, causing her to fall to the ground. The defendant then began stomping on her and repeatedly striking her while Miss Muse was attempting to fight back. Miss Muse attempted to retreat again. The defendant grabbed her by the ankle, pulled her back, and continued the assault. The officers did observe redness, abrasions, and some hair loss due to the incident. Based on the fact that she was determined to be the aggressor, the defendant was arrested. Our recommendation, based on the fact it is the defendant's first offense, is an SOB through pretrial services, level 2. We would also ask for 5 days anger management. Furthermore, we'd ask for no further contact whatsoever with Miss Jonna Muse, that she stay away absolutely from 12515 Magnolia Circle in Johns Creek. If she does need to return for her belongings, that she may return only with a law enforcement officer escort for one opportunity to gather her belongings for no more than 2 hours. Furthermore, we ask for no alcohol, drugs, or weapons and no firearms as a condition of this bond. We would like to sound for Miss Jonna Muse, who is here in the court, and you have already heard her portion of her witness statement to a victim statement to us.
All right. Ms. Muse, do you want to answer a few questions for me today?
Good afternoon, ma'am. Yes, I will.
All right, raise your right hand for me. Do you affirm that the testimony that you're about to give is the truth and nothing but the truth under the penalty of perjury?
I do.
All right, thank you. You can put your hand down. Are you in fear of Ms. Kimbrough?
I'm in fear for her unpredictable nature. Yes.
Do you want to have any further contact with Ms. Kimbrough?
Absolutely not.
Okay. All right. Any other questions by the state?
No, Your Honor. I feel like Ms. Muse was very comprehensive with us in her concerns about this defendant's nature.
All right. And is this PD McLean?
Yes,
Your...
we're meeting now. Thank you. Yes.
Okay. All right. I don't have any other questions. And we just want to make sure, Ms. Muse, that you're going to be safe. Okay.
Yes, ma'am. Thank you.
All right. Thank you. You can mute yourself and wait for the ruling. All right. PD McLean.
Yes, Your Honor, the state and I discussed this in advance. I understand what the recommendation is from the state. We have no objection. The trial will be later. In the meantime, one-time law enforcement escort to get the belongings, and just showing up in court on time will be fine.
All right. I'm going to order a $5,000 signature bond through pretrial. It's $1,000 on each of the charges. I'm going to order that through pretrial to level 2. I'm going to order the 5 days of anger awareness. I'm going to order no further contact with the victim, Jamila Muse. No, it's not Jamila.
Jonna, Your Honor.
Jonna, I'm sorry, Jonna Muse. No further contact with her. The defendant is to stay away from 1215 Magnolia Circle in Johns Creek. She is to not return there except for the one-time law enforcement escort visit that I will allow no longer than 2 hours to retrieve her personal belongings. She can arrange that escort when she gets out. No drugs, alcohol, weapons, or guns while on bond. And I think that's it. Did I leave out anything?
I believe that is everything that the state requested, Your Honor.
Okay. All right. That will conclude this matter.
Excuse me, Your Honor.
Excuse me? Yes.
Hi, it's Milton. For position number 3, she needs to a one-time to go back to get her stuff from the location.
Position 3. Oh, okay. A one-time law enforcement escort for Mr. Gambadon.
Gabadon, yes.
Gabadon. One-time law enforcement escort no longer than 2 hours to retrieve any personal belongings.
Thank you, Your Honor.
All right, thank you.
Next is position 2, Ms. Charles.
Okay. This is 25 CR 003548C. Dederica Charles charged with 2 counts of reckless conduct.
Fourth arrest, 2021-2020. Suspended license, 2014 shoplifting. PTI.
Okay. Okay.
Your Honor, this occurred on June 24th of 2025 at 3030 Headland Drive Southwest in Atlanta. The officers were dispatched to that location. It's a grocery store. Miss Star Jackson, the store manager, stated that the defendant had come into the store with 2 children, one MB, 9 years of age, and one DB, 8 years of age. The children were seen on video placing items into a shopping bag. The defendant then exited the store without rendering payment for the merchandise that she had just taken from the store. When questioned, the defendant, the children were left unattended at the store for approximately an hour. When the defendant was later questioned, she claimed she thought her children were behind her when she exited the store. She did attempt to have relatives pick the children up for the store, but the employees refused to release the children to relatives. The defendant then returned to the scene after learning that the children were going to be released to DFACS custody. The defendant, as you've heard, only has one prior offense that she was sentenced on, which is the theft by shoplifting. The other cases are driving offenses. Kind of sounds like, based on the facts of this case, she was doing that again, just employing her 9 and 8-year-old child to assist her, and then left them unattended in the store once she had taken the items from the store. We are agreeable to a signature bond through pretrial services. We are asking for a parenting course as part of that. We are also asking that she have no alcohol, drugs, or weapons, and that she not return to the store, which again is located at 3030 Headland Drive Southwest in Atlanta, Georgia. If Your Honor will just give me a moment, I can give you the name of that store, but that is all for the state.
Jail was the wreck, but you could level 1 it. I guess if you give a pretrial.
I would
Okay.
prefer to, because I think based
I
on
know you do.
behavior,
I'm just saying.
a parenting class. Thank you, Mr. Howard. I just think a parenting class is necessary based on this behavior. And
Mr. Howard, do
that
you
is
all
the
have- Go ahead.
CVS is located
Oh,
at that.
CVS.
And
Okay.
I'm not sure if it's the CVS. There's also a Kroger at that location. So if I had to hazard a guess, I would say it was the Kroger at that location, not the CVS.
From
Okay.
speaking with Miss Charles, it was the Kroger.
Kroger. Okay. All right. Let me ask this. Do you have a parenting class, Mr. Howard?
We do.
Oh, okay. I was just making sure. All right. Go ahead, PD Tucker.
We have no objections to the state's recommendation for a signature bond. Miss Charles is 34 years of age. She's an Atlanta native. She's completed her high school education, and she does have 5 children, whom she is the primary caregiver for her 4 children that are still living. And so she does need, it's important that she's able to bond out to return home to care for her children. We have no objections to the stay away from the Kroger location, as well as no objections to the other recommendations from the state.
Your Honor, I
Okay.
will just say that children were actually released to the grandmother, not to DFACS. So there's no requirement for following any kind of DFACS plan, because it appears that the children were just released to the grandmother.
Okay. All right. I will give her a $3,000 signature bond through pretrial, 1,500 on each of the charges. With that 3,000 SOB pretrial, we'll put her at a level 1. And I'm sorry, was it 1 or 2?
Well, it's 1.
1. All right. The level 1, stay away from the Kroger on 3030 Headland Drive. And no alcohol, drugs, weapons, or guns while on bond. And parenting class through pretrial. And I think that's it. Anything else?
Is it one parenting class?
Let's do 2. I don't know the length, or is it one that's 4 hours, or if Mr. Howard could tell me, is it 2 parenting classes or 1? I was thinking 1 for each child, but I don't know. Or 1 for each charge.
I don't know how it go. I just know they have parents in class.
Hmm.
Grandma, now,
Do you know Deputy Falk?
I do not.
Well, yeah, they wouldn't know. I mean, I would have to ask, but
Well,
I can try to find out from pretrial services while we're waiting from Mr. Young if he knows the length of the parenting class.
yeah, if it's a 3 or 4 hour, I think 1 would be sufficient. But if it's shorter, we can order for 2.
you could just order 1.
I'll just order 1. Okay.
Yes.
Got it. And that should be it.
Next is position 6, Salata.
Can we hold position 6 to the end of the calendar due to the charges?
Oh, yeah.
All right. Go to position 7, Mr. McIntosh.
All right, 25 CR 0035552G, Leland McIntosh, 1 count of willful obstruction and 2nd count of affray. And I think this was the co-defendant case for
This is 9th arrest.
position, right, 12. Okay.
You got to check your notes for it's a CWAC charge here on probation 4 out of Bleckley County. Also a CWAC related offense out of Bibb. 2022 probation, 2022 failure to appear, 2020 battery conviction, 2020 probation, 2019 terrorist threats, and 2019 shoplifting no law. That's all.
Okay. Thank you. Mr.
And
Shiraka?
thank you, Judge. I have the same, except I have that battery conviction being from 2022. So a little bit more recent. So you're familiar with the facts here.
I am.
Yep. The address again is 180 Shirley Franklin Boulevard in Atlanta, that state capitol building. As you're aware, they were both arrested. The distinction here being that when the officer was trying to ultimately detain the defendant, he ordered him to place his hands behind his back, telling him he was under arrest. He pulled away, started to trying to walk away, wasn't following orders. The officer ultimately had to tase him to get him under control. So that is the willful obstruction there. With the defendant's recent conviction for battery in that 2022 FTA, risk of reoffense here, threat to the community, and also risk of failing to appear. We recommend that the bond remain as set at $1,200 total surety. It's a $600 surety on each count, along with a 2-day anger awareness, no further contact with Nathaniel Powell, stay away from the state capitol building at 180 Shirley Franklin Boulevard, and no drugs, weapons, or alcohol while out on bond.
All right. Dee Tucker?
Yes, Your Honor. Mr. McIntosh is 24 years of age. He is a Georgia native. He's from Macon. However, he has been residing in the Atlanta area for a little while now. He is currently homeless, however. He's completed a 10th grade education. And in addition to being homeless, he is currently unemployed. And for these reasons, we are requesting a signature bond on his behalf. He wouldn't be able to make bond on the $1,200 surety for both charges. So we're asking for a signature for him today.
Okay. I will not grant the signature bond. I'm going to stick with the $1,200 surety, $600 on each charge. Stay away from the state capitol, 180 Shirley Franklin Boulevard. No drugs, alcohol, weapons, or guns while on bond. And that's all I order at this time.
No further contact, Judge?
Oh, I'm sorry. No further contact with the co-defendant.
Okay, thank you.
Yes.
Next is position 13, Mr. Wells.
This is 25 CR 003561A. Tariqus Wells charged with 1 count of battery, family violence, and 2 counts of simple battery.
Fifth arrest, 2022 sale of marijuana. Dismissed. 2019 theft by receiving auto conviction. 2019 obstruction conviction. 2016 entering auto theft by taking conviction. I didn't see any violence.
Okay.
And there was also, I believe, a hit and run conviction from 2017.
Something.
Yeah, Judge, so this took place May 15th, 2025. Law enforcement responded to the gardens at Camp Creek Apartments located at 4555 Washington Road in South Fulton in reference to an assault call for service. Upon arrival, the officer made contact with the victim in this case, Miss Adriana Wells, who explained that she had been attacked by the defendant, her brother. She reported that the altercation began after she asked the defendant to have his guests move their vehicle so that the mother of his child could leave the property. She believed that the defendant may have been under the influence of drugs at this time, and the defendant ultimately became verbally aggressive, calling her out of her name, escalating the situation. And at that point, both of the brothers who had been residing with her, both the brothers had been residing with her, her 2 brothers, since they didn't have anywhere to stay. And she felt frustrated, expressing frustration. She wanted them to leave, was telling them to get their things and to leave. And then the defendant swung at her with a closed fist, striking her, starting this physical altercation, and that started in the apartment, continued all the way out onto the porch. After the fight, Miss Wells began removing the defendant's belongings, and the defendant at that time returned and punched her in the eye with a closed fist twice, and then continued to punch her repeatedly and held her down, refusing to get off her until her friend and the mother of the defendant's child intervened and separated the two. Ms. Wells further explained that after this altercation, both of her brothers made threats against her, stating they would have her set up and her residence robbed, and that they were in possession of firearms. The defendant warned her not to contact anyone about the incident, threatening that if she did, he would return with the others to shoot up the home. The victim complained of the throbbing pain in her eye, which was observed to be swollen and bruised. She stated she wanted to press charges, and the defendant was not on scene when law enforcement arrived because once the defendant realized that she had called 911, both he and their younger brother fled the scene. We have not yet spoken with Ms. Adriana Wells. We will continue those efforts, but we would nonetheless ask the court sound for her. Given the threats alleged here, to have her set up to be robbed, the statements about being in possession of firearms, and the threatening to shoot her if she told anyone about this, there's a risk of reoffense here and a risk of witness intimidation. We are concerned for her safety. So the state's recommendation for this case is a $5,000 surety, $3,000 on the battery family violence, $1,000 on each of the simple battery family violences, for him to complete FFIB, undergo alcohol drug evaluation and any treatment if recommended. Have no further contact with Adriana Wells. Stay away from the gardens at Camp Creek Apartments. That's at 4555 Washington Road in South Fulton. Surrender any and all firearms to the sheriff's office, and have no drugs, weapons, or alcohol while out on bond.
All right. And Adriana Wells. All right, she's not on. PD McLean.
Person. Okay. You're on Tyrekus Wells, is it?
Yes.
Yes, he's 27. Your Honor, stable address, with his grandmother receiving mail on Shepherd as listed in Odyssey. Graduated from a local Atlanta school system, a high school, with the augmentation of a program that was a youth challenge. He's worked at a restaurant for a half a year. He's also off and on done demolition work for 9 years. So we would ask for the lowest possible honor.
All right. I'm going to order the $5,000 surety bond, $3,000 on the battery, $1,000 on each of the simple batteries for a total of $5,000. No further contact with the victim, Adriana Wells. Stay away from the gardens at Camp Creek Apartments. No drugs, alcohol, weapons, or guns while on bond. And I believe that'll be it.
Would you grant Judge the condition that he surrender any and all firearms?
Oh, yes. And if he has any firearms in his possession, he should surrender them immediately to the Marshal's Department or the Sheriff's Department.
Sheriff's Department works, Judge.
Sheriff's. Mm-hmm.
Yeah, that'll be moved. Thank you.
All right, thank you.
Next is position 14, Mr. White.
25 CR 003557G, Joshua White, charged at 1 count of criminal trespass.
7. Got an open fleeing, no headlight, obstruction, driving without a valid license. 24 SC 005192. Got an open case for suspended registration. Open simple battery DV 21 CR 007248G. 2012 burglary, theft by taking first offender.
All right, state.
Yes, Judge. So this took place May 2nd, 2024. Law enforcement was dispatched to a call at 2479 Abner Terrace Northwest in Atlanta. Upon arrival, the officer met with the caller and victim here, Miss Shatavius Whitehead, who had explained that the defendant, who is the father of her children, who used to live with her, came over to her apartment and began banging on her door. She explained that the defendant then proceeded to rip the window screen off of the living room window, and that the defendant continued to further hit her door before leaving the location. A defendant was described, and she also explained to police that there had been a previous incident involving the defendant from March 27th of 2024. I don't have details on that, but during the investigation, it was discovered that in September of 2021, there was an incident where the defendant was arrested, and that case, Miss Whitehead was the victim in that case, which for which the defendant was arrested December 2021. And the damage to the living room window was estimated to be roughly under $500. Warrant was issued for his arrest. I want to get to that other case referenced in the report here. That is a dormant bench warrant case, 21 CR 007248G. It's a simple battery family violence case where he is accused of pinning the same victim as our case here down to the couch and biting her ear while both of her children were in the home. He was originally given a $3,500 good bond from Judge Wall for that, and was supposed to have no further contact with Miss Whitehead. That bench warrant was issued August 24th of 2022. Given the defendant's open cases, namely that simple battery family violence against the same victim, he poses a risk of reoffense here, of returning to a residence and causing further injury to her property or her. So the state is seeking a $3,000 surety here. We would ask that you have no further contact with Ms. Shantavius Whitehead, to stay away from 2479 Abner Terrace Northwest in Atlanta. Have no drugs, weapons, or alcohol while out on bond. And if we could sound for Miss Whitehead at this time.
Miss Whitehead, Shantavius Whitehead. And so to make sure I'm clear, ASG Scirocco, he had a prior bond in case of the same victim, so he's violated that bond?
Yes, I believe so, Judge. That is, it does appear to be Miss Whitehead that he has since had contact with, so yes.
So usually when I have a second and third and they continue to victimize that same victim, I usually do a cash bond on the second one. So let's hear from PD McLean, and then I'll see.
Your Honor, he is 33 years old. He's had a year and a half of college at Fort Valley. He'll finish up his degree later on in history and poli-sci. He's had a year of warehouse work and 4 years, 3 years in one place and 1 year prior to that at another, as a manager at a retail establishment. He would ask the court, he's got a stable address. He would like to ask the court to give him the lowest possible bond that would be reasonable here. If that would be a surety bond, great. But if it's not a surety bond, he would like to ask the court to consider $1,000. Excuse me. If it's not a signature bond, he'd like to ask the court for $1,000 surety bond. Thank you.
Okay. Given the criminal history and the continuous victimization of the same victim, victimizing her, continuing, I'm going to order a $5,000 cash bond. And with that $5,000 cash bond, I'm going to order that he stay away from 2479 Abner Terrace, that he have no further contact with the victim, Shantavius Whitehead. This is to stay 200 yards away from her, which is 2 football fields. no contact with her whatsoever through social media or other third parties. He is to have no drugs, alcohol, weapons, or guns while on bond. And I think that's it. Anything else? Mr. Shirako?
I do believe so, Judge.
I can't car no, I take my kid, I'm the only driver in that house. If I can't get out of jail today or tomorrow, my family is done. My livelihood is done. My wife, the woman that has me in here, she will be put out of her house. I pay the rent there.
But we can't keep having cases, so.
Man, that joint is petty, bro. She does it out of spite. Come on, man, come on. $5,000? Come on. What the freak? That's some bullshit, bro.
Next is position 6.
This is 25 CR 0035558G. Dustin, is it Lauter? Okay. And we charge it 1 count of PI. Can we stop the live stream, please?